So from a disability and estate planning perspective, um, and as a lawyer that practices in this area, for me it's important to ensure that we're aware of the many practical and tax and disability benefit considerations when designing that estate plan. And as I said, provincial disability benefits are typically one of the main criteria. Um, and we want to ensure that when we're planning, we're ensuring that our families, our clients with disabilities are going to remain eligible to receive disability assistance regardless of any potential inheritance. So it's important, I think, before we get into sort of what options are available, to sort of get an understanding of some basic eligibility criteria for persons with disabilities to receive provincial benefits. And so under the legislation, and I won't refer to the full legislation, it's on the PowerPoint there, you must be 18 years of age, and so a lot of families start to plan for provincial benefits, usually at the halfway point of the age of 17, so that we're ready to go when you're 18. You must have a severe or physical or mental impairment that is expected to continue for at least 2 years. You must be significantly restricted in your ability to perform daily living activities and require assistance with daily living activities. I think it's also important to recognize that provincial disability benefits is quite distinct from federal disability benefits, and we're not intending to have any sort of discussion around federal benefits tonight, but the criteria for eligibility, whether it's provincial or federal, is quite significantly different. And we have many clients that may be eligible provincially, but may not qualify federally. And that can have some impacts because there are now some changes around tax laws that require individuals to have eligibility for the disability tax credit, for example, which is a federal initiative. But we're going to focus predominantly tonight around provincial benefits in British Columbia. So, and as I go through the presentation, I'll try to highlight as well some significant changes that have occurred over the last year around benefits. And one of the most obvious changes, and one of the most important ones that I've seen in a long time, is the government's initiative around prescribing, I should say, a class of those that are eligible for an automatic PWD designation. Many people with disabilities have been and were frustrated with the continuous process of having to declare themselves re-eligible for disability and would have to apply for different items to declare that disability. And so, again, kudos to government in British Columbia for seeing this as a concern and recognizing that we needed to come up with a better system so that people don't have to apply on a regular basis with other programs. And so there's a number of categories that were implemented that effectively shortened the PWD application process. And so individuals, for example, receiving CLBC funding, receiving funding or enrolled in the Ministry of Children and Family and Development at Home program, the PharmaCare palliative care program, and then, of course, if you already have eligibility federally for disability benefits, you're automatically deemed to have benefits provincially. So it's a good start. I think we still have a long ways to go in terms of designation, but hopefully it's the beginning of some better things. And Angela, please stop me if you want to jump in on any of these issues or ask any other questions.
I agree with everything you said. I know that the application when they were 17. Very, and in addition to the expedited, they've also implemented an online education, which is much easier as well. And so, we're partway there. We're moving in the right direction. Very exciting.
Absolutely.
Still got a long way to go, but
it is, and I guess we need to move forward. I mean, the intention here is a 10-year plan. So, we're a few years away from the end of that 10 years, but, we're getting to that point where we're starting to build, I think, peace of mind for families and, develop that foundation. So some other big changes that have occurred in the disability and benefit sort of legislative and policy realm is around asset limit increases for persons with disabilities. That was one of the first items that was implemented back in December of 2015. It used to be that you could have up to $5,000 in assets for an individual receiving PWD. That, effective December 1 of 2015, was increased to $100,000, a significant jump in the ability to hold assets. And this is really important because, again, it recognizes that, we want to support folks with disabilities in the community to be able to have assets without being penalized. I should add that exemption limit is $200,000 for a couple where both adults have PWD, and again, that's an increase from $10,000. The other area of exemption that is still evolving is under the area of gifts, inheritance, and trust payment exemptions. In British Columbia now, the province has actually now stipulated that cash gifts, inheritances, and trust payments will not affect eligibility for assistance. And what does that mean? Well, in terms of gifts, I think it's been sort of a recognized issue, and maybe you've seen this, Angela, with families that traditionally with the disability benefit amount being so nominal, it really doesn't have the ability to support additional items beyond rent and some very basic food items. And so I think families have become accustomed to helping and supplementing their loved ones with disabilities with additional gifts of cash. And so it's been happening for years, and I think government recognized, why are we penalizing individuals just because they need a bit more food in their fridge, or they need a few more dollars to enable them to pay the rent that their current shelter component doesn't enable them to. And so I think what government said is, folks are doing this anyways. Why should we penalize it? So one of the policies, and I think the challenge for families and even for planners in understanding this is, are there limits? And the government unfortunately hasn't really issued any sort of real criteria that sort of guides us and provides some important knowledge so that when we're making these decisions, we're not unduly impacting a person with a disability. But around trust payments, there are no exemptions now. And I'll touch on that a little bit more when we get into the actual area of trust. You want to jump in?
I was just going to ask you a question. So with the asset limit increases, and I know we've just going backwards, but can you give an example of what an asset would be that is a non-exempt? Like what would somebody be allowed to have? Does that include a home? Is it a car? Is this an investment?
You're great. You're anticipating questions that I'm going to touch on. But and generally speaking, there are a number of exempt assets that are prescribed by the legislation. And the most basic ones are, of course, the principal residence, the $100,000 now, a vehicle, household items. Those are seen as the major asset exemptions that are permissible. And then, of course, the trust. So funds held within a trust, and which is going to be the basis of our discussion tonight, those are also exempt. So, and then there's one other one that we're probably not going to be able to spend a lot of time tonight, and that is the RDSP. So the Registered Disability Savings Plan also is an exempt asset in the eyes of disability benefits. So any of those assets are exempt. And so, from the perspective of planning now, we now have a number of tools really available to us that we never had before. And this really, I think, makes our job more interesting. But it also gives families, it gives people with disabilities a little bit more flexibility in terms of the options that are available. And so not one option fits all. So for example, a house. Maybe having a house is great as an exempt asset, but is it practical? Is it realistic? If somebody doesn't have, let's say, capacity to manage the property. So we might not want to put that property in the name of that disabled child because it may actually create more problems than it will resolve. Yes, it's exempt, but if there's a need to sell the property, renovate the property, refinance the property, that person with a disability may not be able to do that. So it really depends on the individual in terms of what assets we're going to look at. And I think for families, it's really important to have just awareness of what are the options, and then trying to flesh out a plan that's going to meet that family's needs and also provide some comfort moving forward.
And it is complicated, which is one of the reasons why we have you tonight, because we can maybe read some of the information and assume some things, and making an error in any sort of disability or estate planning or assumptions around what we're allowed to have or what our sons and daughters are allowed to have, and having it not correct can result in a whole lot of damage. So it's a good thing that we kind of pay attention to the complexities. And
I think that that is really the intention here, is to arm families with a foundation of knowledge that they're going to be able to take. And even if you don't get all of this tonight, you're going to get a portion of this. You're going to understand it, so that when you sit down with your own planners, wherever you are, you're going to have some knowledge. You're going to be able to ask the right questions. You're going to be able to ensure that the advisor that you're working with is going to be able to lead you in the right direction and ultimately come up with a plan that's going to meet your needs and your family's needs into the future. So some other asset and income exemptions that I just want to touch on. One big one is the earnings exemption. So anyone receiving PWD benefits, we talk about assets, well, what about income? And so one of the other initiatives of government is that we want folks with PWD benefits to be able to go out and earn income if they can, even if it's part-time, and we don't want to penalize them because of that. And so one of the other big changes in December of 2015 was an earnings exemption that would be annualized over the entire year. So it used to be, and this number has changed, used to be $800 per month. Somebody on PWD could earn $800 and still receive their provincial benefits. And what government recognized was that, people with disabilities may have times during the year, maybe seasonal times, when they're more functional, more able to earn dollars. And so what they've said is, look, we're not going to tie you down to that $800 a month. What we'll do now is we'll actually annualize it. So if you earn $9,600 in a few months, you're not going to be penalized. And so you might just be able to work, let's say, over the summer. When the weather's warmer, you're feeling a little bit more functional, or you're working in seasonal activity. So you're going to be able to earn, if you have PWD benefits, up to $9,600 a year and still receive those PWD benefits. And that's a huge thing because what it does is it encourages folks with disabilities to go out and seek employment.
I just saw an example of a form where people can log their annualized earnings. And it can be done both electronically
That's
online
right.
through my self-serve, I can't remember now, but or it can also be done on paper in the offices. And so government is trying to make it as easy as possible by just having pull-down boxes and really simplified forms. So it looked pretty good. I didn't get to test the form like it.
That's great. I wasn't aware of that. That's a great thing
Yeah,
to see that that's actually being implemented and supported as well.
yeah.
The other area of exemption, which is a relatively newer one, was September of 2015 around child support payments. Those are now also exempt. There was a lot of media attention around that in the last year. So notwithstanding all of these great vehicles that we have, um, you know, and the ability now to plan, um, estate planning and a properly designed plan now still, in my world at least, trusts continue to be very useful. Um, and so, these legislative challenge or changes that have occurred are obviously very effective and are offer more options for families. But, there are circumstances where even those vehicles, as I outlined before, may not work. And so, the most common situation is someone receiving benefits that is simply unable to manage money for themselves due to capacity or, very commonly, a higher level of susceptibility. And so we want to be able to think about planning for those individuals and recognizing those characteristics in addition to potentially preserving provincial benefit. So the will is the common vehicle that we utilize as a starting point to our planning. And so one of the first questions we always ask folks when we're talking about wills is, why everyone needs a will. And I think one of the best ways to sort of answer that question is, what happens if you don't have a will? Angela, do you have a sense of that?
Yeah, well, I mean, there's a whole lot of different, but certainly any of your assets won't be directed at any person to get tied up either in probate or I don't exactly know where they would go, but they might not go to where you want them to
Exactly.
And similarly, not just cash, but there's also things like your assets, cars, and things like that. So those are really important things that you want to be able to direct.
So the other thing in our province, when you don't have a will, we have legislation called the Wills and Estates and Succession Act, or the acronym which is WESA, W-E-S-A. And effectively WESA, which is really designed by legislature, articulates a distribution and a plan for your estate when you don't have a will. And I think the key point, which you've hit on the head here, is that you lose control. You don't have the ability to make decisions about who's going to get what. What you've done is you've left it now to the government to articulate what the distribution plan is. And that may not be what your wishes are. And so it's a very archaic sort of distribution scheme. And it doesn't contemplate a disability in a family. It doesn't think about that. And so by not having a will, you actually open the door to some potential problems. In addition to the obvious lack of control over your estate. And you can see from the PowerPoint there, there are some fairly arbitrary distributions if you don't have a will. The estate would go to your spouse. If you have more than one spouse, and yes, in British Columbia you can, have more than one spouse. Or if you have kids, a portion would go to your spouse, a portion to your kids. And it will depend, of course, on whether those kids are from the same marriage or another marriage. Um, and if you have no spouse, all to your kids. If you have no kids, to your parents. And on and on. And so you can see that distribution may not be what your wishes are. And so therefore, it looks like making a will is obviously the easier approach. But it also is important in the context of families with people with disabilities, in that in our province, most estates, of course, I know definitely in the Lower Mainland, most estates are worth more than $100,000. And so, as I said, dying without a will could have some pretty significant consequences for someone receiving provincial benefits, because if you exceed that $100,000 amount, you've now jeopardized benefits potentially for your son or daughter. Another area that a lot of folks are not aware of is that a will allows you also to appoint a guardian for your minor children. And having that appointment, I find, is very, very important for young families with young children. Not having the guardian appointment could actually delegate that responsibility to the children of families, and that may not be what your wishes are. But also, the public guardian and trustee might actually then take responsibility for managing your children's financial inheritance. And again, that may not be what your wishes are. I'm a big believer that families have a better understanding of their family members' needs, and not government. And we should not rely on government to take on that responsibility, because they're not going to know your son or daughter as well as you do. And so taking control of your estate is vital to ensuring that you've got confidence in the future of your children.
Really, everything you've just said about families knowing their sons and daughters best is kind of the foundation, actually, also of the work of the
Absolutely.
is that we believe the best. So should be the ones.
Well,
decisions.
And I think the other risk as well of relying on government, aside from not knowing your family members, is that there's a cost to taking on that role. And so both, the public guardian and trustee and the Ministry of Children, they're not going to take on that role freely. They're going to expect to be compensated, and they're going to look to your estate to fund their costs. And I think a lot of folks just assume, that's a great last resort option, but a lot of families don't realize that that is one of the most expensive options in our province. In fact, the public guardian and trustee rate is likely higher than all of the top banks in British Columbia. So the rate of fees that they would charge for that role are going to be significantly higher than if you were to, say, go to a BMO or a TD or a Scotia. So something to be mindful of. So developing a will clearly gives you control. And what we want to do is empower control with your plan and with your assets and with your family. So what does a will do? It allows you to appoint an executor or a trustee. So this is someone that would manage your affairs. Allows you, as I said earlier, to appoint guardian for minor children. Distribute your estate in the amounts into the persons you wish. And most importantly, setting up the potential of trust to protect vulnerable beneficiaries.
Is there anything to think about in terms of appointing an executor or a trustee?
If I can ask you to hold on to that, I'm going to touch on that a little bit later, and it's a very important question. one that I think many families struggle with. And it's why I find that once families have made the decision to plan, the decision of who's going to execute that plan when they're not here, I would find occupies most of our discussions. And it's a very, very challenging question because I think all of us have a belief that families are unique with family members with disabilities. And a lot of these folks feel that really no one else could do what they do. And in fact, I've had situations where sometimes it's an army of individuals that actually replaced, family members. In fact, I just had a discussion this morning with a mom who, was able to take a 5-day vacation, but had 4 people taking care of her daughter during that 5 days. And so that's astonishing. To think that families, to take that sort of a respite vacation would need to have that much planning involved. And so, much like the planning of an estate, ensuring that you have a team ready to take on a very important responsibility, and choosing a trustee, choosing an executor are really going to be important. So I'm going to spend a pretty large amount of time on that a little bit later. I want to touch on something that is a bit unique as well to British Columbia and estate planning, and that is the whole topic of wills variation. We're the only province in British Columbia that actually has legislation embedded in that WESA legislation that I mentioned, which actually articulates a moral and a legal duty that individuals have to spouses and to their children. It used to be that I would be approached by families in the planning for their children with disabilities, and the discussion would arise to such the point where the families became frustrated with the process. It was too overwhelming. And rather than doing all this planning, their suggestion would be, well, why don't we just leave everything to the sibling without the disability and let them take over. Let them manage the money and take care of their disabled brother or sister. And that's a dangerous step in our province because it opens up your estate to potential wills variation in British Columbia. And what it does is it also potentially exposes those assets that you intend for a person with a disability to others, perhaps a family member or a friend. And so the other question that I get asked around wills variation is, well, my son or daughter with a disability would never do that. They're never going to challenge my will under the Wills Variation Act. And so my answer to that is, well, it may not be your son or daughter that does that. It may actually be the public guardian and trustee that initiates that. One of the requirements for probate in British Columbia is that when someone passes away and we're proving their will at the level of the court, there's actually a duty to provide notice to the public guardian that there is an individual with a disability. And so the public guardian would actually see the will, potentially the will without a distribution for a person with a disability, and red flags might start to fly for them. And what they might then do is they might actually initiate a wills variation challenge against your estate because you haven't provided for your son or daughter. You haven't upheld your moral duty to your son or daughter. And simply stating that the disability created so much challenges in terms of planning would not suffice in our legislation and in the common law. And so that litigation potentially could be also very costly. And the public guardian would likely retain a lawyer. They would actually have that lawyer funded from your estate.
Right.
And likely they would be successful, especially in today's day and time with all of these vehicles available. So I guess in a nutshell, not leaving a gift for your son or daughter with a disability is not a viable option, and actually may create a lot of problems for your estate when you're no longer here. The key, I think, to remember in our province is that wills variation is a relevant planning vehicle that needs to be well aware of in designing a plan. And so leaving a child with disability out of a plan can add some real challenge, but it creates some very significant. The good news is you have an answer. And the answer is that there are just that can be utilized to ensure that we're planning for that. And so the Ministry of Social Development and Innovation has articulated in our regulations that trust is not treated as an asset of a person receiving. And so an individual would continue to receive their while still having that. Again, it's another exempt asset. And those funds that are held in that trust could be utilized for meeting various costs, not only today, but it still remain eligible.
And that is in addition to that 100,000 or 200,000. Right.
RDS, and then vehicle. You've got a wealth of variables
Absolutely.
to consider now, and so you might have maybe you'll have a trust for some, maybe you'll have $100,000 viable. Some there are a number of